Good afternoon, good morning, whatever time you're watching. I am Stephen Leskin, no matter when you are watching. And tonight's topic is Oregon Divorce School is self-represented forms. So doing the forms for divorce for self-represented people. Hey, let me start. Tonight's webinar is going to be a little different from past webinars. I'm actually going to pull up the forms online and we'll go through them. I'm not going to go through each form and explain what each form means, but I will talk about the process, what's necessary, where to find the forms, and then what it takes to actually get the divorce running or finalized, depending on where you are with your spouse. So my name is Stephen Leskin. I am a divorce attorney in Portland. I've been practicing law here since 1992. You can find me online at www.leskinlaw.com. If you are happy, if you enjoy the webinar, give me a shout out, give me a review or a thumbs up or something. Those always help. So the other thing I would say is usually when I start these webinars to say don't take questions during the webinar because they distract and lose my train of thought, and then I can't get back to where I was, and it's really embarrassing. So I usually say, just call me or write me, just shoot me an email with your questions. Tell me you watch the seminar. I'm happy to chat with people. I do it all day long. I'm just happy to chat with people. Um, this is going to be a little different. Please do not call me and ask me to help you fill out your forms. I won't be happy about that. I get those calls all day long. I don't offer that service. I will tell you where to find the forms. But if you're looking for somebody who will sit down with you and go through the forms, there are plenty of paralegals out there who will do that. St. Andrew's Clinic in Portland has a kind of a mini clinic where you can do that. So there are options for that. My goal here tonight is just to give people a familiarity if you were going to do your own divorce and do it yourself divorce. All right, so let me jump into it. There are a couple of things I need to clarify up front, and a couple of distinctions I need to draw. Uh, there is do-it-yourself divorce. You fill out the forms yourself, you turn them in, and the court signs them or they don't, and they give them back to you. You go to trial, you fill out the forms, and so a do-it-yourself is where you're completing all the court documents yourself. People seem to confuse that with an uncontested divorce. Uncontested means that you and your spouse have all of the issues worked out, that there's no light between you on any topics that you're going to, on any issues between you, and you can come away with a clean divorce without any um, either of you saying, well, no, I thought I was going to get, or no, I thought you were going to take. So uncontested is, it's not adversarial. The parties agree on all of the points, and you're going to do it yourself. Uncontested, you can hire a lawyer to do it. I do them. I charge a minimum amount of money to do an uncontested divorce. Uh, uh, um, so you can do an uncontested divorce yourself, or you can hire a lawyer. Do it yourself means that it's either uncontested or it's not uncontested, but in either event, you are doing it yourself. The other quick thing I would say about do it yourself divorce, I did a webinar 2 weeks ago, a month ago, about the difference between uncontested divorces and contested divorces and mediation. And what I said then and what I'm going to repeat now is that uh, people want an uncontested divorce. They want the least friction as possible. So they'll say to themselves, "Well, we have an uncontested divorce. All we have to do is fill out the paperwork." There are certain issues that are so complicated to do, like dealing with the children or dealing with real estate, that um, you're likely missing a lot of details if um, you do it yourself for anything other than the divorce. Couple, like they've been separated for years, there's no kids, there's no property that's going to be exchanged, there's no spousal support. Spousal support, you don't really need an attorney to do. You can fill out the form, you can come to an agreement with your spouse and fill out the form. Of course, the issue of spousal support is a lot more complex than that, but you can certainly say, wife is going to be a husband, spouse support for 3 years, for $300 a month. You can certainly fill in the forms to do that yourself. But the do it yourself has a lot of risk to it. And I will give a couple of examples. Uh, suppose you fill out the um, debt section and you and your spouse have a joint MasterCard. And it's a joint card. The creditor MasterCard is extended the credit to both names. Um, and the divorce decree says that wife is going to take the whole amount. Wife stops making payments. Who can MasterCard go after? MasterCard can go after both husband and wife. They're both on the account. Husband can't hold up the divorce decree and say, I have a signed order from the judge that you can only go after wife, right? That's not how this works. MasterCard was not a party to the divorce. The court has no authority, no jurisdiction over MasterCard to tell them who they can collect from or not. And that's just a common misunderstanding that happens that I see a lot, that people think, well, the divorce decree says, well, it doesn't, it only pertains to the two people who are getting divorced. So that's like one example of something that people get tripped up on. The state forms that are out there don't necessarily do a good job of providing recourse for the eventuality that wife fails to make her payments, right? An experienced attorney will have that necessarily in their in a uncontested divorce or a contested divorce, like dealing with the risk that somebody is not going to pay uh, their obligation under the divorce decree. I once had a issue. I thought that this was just kind of nuts, but whatever. A couple had a house and they decided that they were going to live together, got the divorce, going to live together in a house for a couple of years. I don't remember, 3 years, 5 years, a long time. And so fine, that's okay. But then at the end of 5 years, they were going to sell it. But what they didn't deal with was like how they were going to split the equity in the house, right? Like who's going to get it, right? You're going to split it, right? Or maybe the person who's paying the mortgage payments is going to get it, or um, who's going to account for other debt, or maybe there's a lien on the house, or maybe there's taxes that are owing, or maybe one of the parties put a down payment on and they want it back. Like none of that was covered because they used a state form. And it becomes a real question of law whether or not the court can go back. A court by law cannot modify a property decree, right? So if there's an issue of property being divided, the court does not have the authority to go back and change what the parties agreed to. So they had a real conundrum. My suggestion was that they just hire a mediator or an arbitrator and just make a decision and then file a supplemental judgment. But I don't know if they did that or not. They didn't hire me. But there are those kinds of risks to doing it yourself. The other thing, that I would caution against is that anything dealing with kids, A, it's important, and B, you want somebody who has some perspective, some long-term perspective when putting together a parenting plan. I will talk about the state parenting plan in just a little bit when we get into it. The state has produced, it's the state parenting plan form is like the one really good form that the state does. Like, I'm not a fan of the state forms, but the state parenting plan form is what I use. A couple of weeks ago, I was working with a couple and we were like in a mediation and we were filling out the form, and it was like confusing to me too. I've been doing this for a long time. So these issues are just confusing. Getting it done right is confusing. Maybe, and then like understanding like the purpose of the parenting plan, and like the way you put the parenting plan together. Like it's important to know that like it's going to change, right? It's like as the kids grow up, that's a change of circumstance. If you're getting divorced when the kids are 5 and 6, it's going to be different from when they're 12 and 14 necessarily. So you have to, and so you're going to go back and modify it. But just having somebody walk you through like the long-term perspective of like what these documents mean is in it's important, it's invaluable. So if you can afford to find legal help, um, it's just it's better to have somebody helping you out. So no judgment if you can't or you want to do it yourself. But from my perspective, having somebody who has a longer view of how things are supposed to work, uh, is just going to save you grief later. So the two, so this was a long talk about the distinction between do-it-yourself and uncontested, but it's just important. Those terms get thrown around a lot, and they're certainly not synonymous. Uh, and just the last comment I want to make on uncontested is that this is not necessarily true of do-it-yourself, but it is true of people who call and say, "I want to do an uncontested divorce." People minimize, right? Like it's calling the plumber and saying, our toilet's backed up, uh, but really what's going on is your sewer line out to the street is backed up, right? So like people want to minimize. People don't want it to be that complicated. They won't think like minimizing it's going to cost less. That seldom works. So you got to be a little and like so the thinking is, oh, spouse and I are agreeing on everything. And it's like, are you really? Like, have you really sat down and like made a list of everything and who's going to get what? Um, or have you really had the hard talk about like how you're going to fill out the parenting plan together? If you can do it, do the paperwork and then figure out whether or not it's uncontested. If you guys can't do it, then it's not uncontested. There are plenty of couples, and just to be clear, there are plenty of couples who do their own do-it-yourself divorces, do the state forms. They do it together. They sit down at the kitchen table, and they're fine, and they're good to fill them out and submit them to the court, and the court approves them. Good for them. That's great. Um, uh, um, but there are a lot of people who just like there's a lot of wishful and magical thinking going on in the process. So that's my perspective from somebody who fields these calls all day. So just to recap a little, who should do an uncontested divorce? Not a do-it-yourself divorce, even though there's some overlap. But who should do an uncontested? In my view, it's people who need the divorce. They need the court to sign off on the divorce decree, and they have assets and some debt that they need to split, and they can split either by just taking it or maybe everything's in their own name already. That's fine, perfectly fine. You don't need an attorney to do that. You can do those forms yourself, and those are likely uncontested. But people who should not be doing um, do it yourself, where there's kids, where there's real estate, where there's a 401k or a pension, those all require special um, technical and really sophisticated legal ability to get some of that done right. And you want to do it right. You don't want to find out, you don't want to think that you have a retirement account and you go to retire and you find out that the transfer wasn't made and it's been 20 years and the judgment has expired and you don't have any recourse, right? If you wait to, suppose you agree that that the 401k is going to be split through a quadro, uh, and then you don't take care of the quadro, and 20 years goes by or 30 years go by, and like I'm ready to retire now. Where's the retirement? If the judgment is expired, you are SOL, and that does not stand for statutes of limitations. So, um, there's a lot to know. And if you don't know what the word quadro means, if you have a 401k and you don't know what the word quadro means, right? So there's just a lot to know, and there could potentially be a lot riding on it. And for the cost of hiring an attorney, call around, shop around. I worked at a firm that did uncontested divorces, and inevitably they run into the eight, nine, and $10,000. Like that's just ludicrous. That is just crazy. But if there's kids, $4,000 or $5,000 maybe not be unreasonable. So call around. Um, it's you just foreclosing. Think about the people who didn't like deal with the equity issue in their house, right? So a couple grand now would have saved them so much grief down the road. right? And they probably ended up paying a lawyer anyways to get it sorted out. So um, again, people don't have the money, and like, fine, I get it, but there ought to be a way to make it work, um, uh, um, so that particularly in those circumstances where there's kids, a house, retirement accounts. Um, all right, so let's turn to what forms are required for an uncontested dissolution. So maybe you want to take some notes here. Uh, we're going to look at the state forms in just a minute, but I want to explain the process and the uh, forms that go along with that process. So this is for an uncontested divorce, and then we will talk about where it branches off into a litigated contested divorce. And remember, there's three. The ultimate goal, of any divorce is to get a signed divorce decree by a judge. You want to get the divorce decree is what divorces you, and that's what you want, right? That's what you need, is that judgment dissolution signed by the court. And there's exactly three ways to get there. One is you agree to everything and you both sign the judgment, and then it goes to the court as a stipulated judgment. Number two is you don't agree to anything and it goes to trial, and then you have a trial, and then the judge decides, and then the judge signs the divorce decree, and you don't have to. And then the third, which we're not going to talk about, is a default judgment, where you file the divorce papers and the spouse doesn't show, is served, and then doesn't show up. So those are the three types of judgments, and we're going to talk about the different ways to get to the stipulated judgment, because that's ultimately what we're trying to do here, get to a stipulated judgment where you both agree. So any lawsuit, I've said this over and over again, any lawsuit starts either with a petition or a complaint. A petition is when you're requesting something of the court. And so in a divorce case, you're petitioning the court for the divorce. Complaint usually means that you want something from somebody else, right? Like I got a complaint because I filed a car accident, so I'm filing a complaint against another party. And then there's like also criminal complaints, which get a criminal case going. But that involves a third party. But a petition is you're petitioning the court for something. So the first document that you have to know about, and again, we're going to look at these, is the petition for dissolution or petition for custody if there's no marriage and there's just minor children are involved. In Oregon, the next three forms that we're going to talk about are something called a confidential information form, and then the notice of confidential information form. The person filing the divorce files the notice of confidential information form and the confidential information form. And so maybe you can deduce this from the name of the form, but it's a way to submit birthdays, driver license numbers, social security numbers to the court, and nobody has access to those. Only under limited circumstances do people get access to that information. And then if it's an uncontested divorce, the other document that you would file if it's a divorce, not necessarily just a custody case, but if it's a divorce, you're going to file something called a Oregon Health Authority vital statistics form, right? You can get that from the courthouse or download it from online, and that gets filed. And then if it's an uncontested divorce, all of those documents are going to get filed with the general judgment of dissolution signed by both parties. That's what you want to do, right? So you're going to prepare those 4 documents and the general judgment of dissolution and a declaration. I'll come back to that in just a second. But those are the basic documents that you're going to file together for an uncontested divorce where everybody agrees to everything. You're also going to file, in addition to the petition and the confidential information form and the notice and the vital statistics form and the judgment, you're going to file a declaration of petitioner, and it's the petitioner, not the respondent, who files that. And um, it's a sworn statement under oath of the contents of the judgment, right? So you were swearing under oath in the declaration that you in fact have residency in Oregon, for example, that these are your children, that you were lawfully married, that there are irreconcilable differences between you. And the importance of that form is that if you file a false judgment, the court has some recourse against somebody who files a false statement because the judgment itself is not sworn, right? So even if you send um, a stipulated judgment, there's no sworn statement in that, and it really, for technical reasons, it can't be, because there's orders in there signed by that, it's coming from the court. It's not really the party statement. So that's why the sworn statement is put in another document. But that sworn statement gives the state or the court grounds to bring a perjury charge if the contents of the judgment are incorrect or inaccurate or outright false. Um, so I think the best example would be in Oregon, you need 6 months residency before you can file a petition for dissolution. And so somebody puts in, they just moved to Oregon last week and they want to file, and they put in the judgment. We've lived here for 6 months. Um, if it turned out that they, if it turns out that they, and they put the same statement in the declaration, if it turns out that they weren't living here for 6 months, the court would then have the ability to file a complaint with or request or file a police report with the DA, who can then do an investigation and find out that they hadn't been here for 6 months and possibly bring perjury charges. I have never heard of that happening. I have never even heard of that happening. I'm not even sure that most lawyers understand that, but that's the purpose of having the declaration, so that the court has some issue to maintain its integrity when it signs a judgment, that it has some certainty or some degree of certainty that the facts contained in the judgment are true and accurate. Okay, so if you're doing an uncontested divorce, a do-it-yourself uncontested divorce, those are the documents that you're going to file, and I will recap them. A petition for dissolution or a petition for custody if there is no marriage. The confidential information form notice and the 2 confidential information forms, the vital statistics form, the declaration, and the judgment. That's all the paperwork you need to do an uncontested do-it-yourself divorce. Of course, it gets more complicated. If there are children involved, there's at least 2 more documents that have to be attached to the judgment. The parenting plan, which can be incorporated into the judgment itself. Usually it's a standalone document, but certainly the other document is not a standalone document, and that's the child support calculation. You're required by law to attach the child support calculation to the judgment in the event that there are minor children, right? So there are other documents that have to go along with the 4 or 5 or 6 other documents that get filed. So that's an uncontested divorce. And I'm gonna pull up the forms in just a minute. I'm just kind of giving an overview, right? So you'll see what we're talking about. 2 minutes. So if, supposing you and your spouse, you don't see eye to eye on anything, and you want to do it yourself, you don't have money, or you just want to do it yourself, you are going to file some additional documents, and you're going to have to make service on your spouse. Those documents will include a summons, the petition, um, and then the other documents are what's necessary to get the case going. Eventually, you're going to have to serve a proof of service on file it in the court. You're going to have to hire a processor. The processor goes out and spouse the petition, and then that proof of service gets filed in the court. And then you are on your own with doing discovery, with doing interim motions. Supposing a spouse comes back and says, well, I want interim spouse support, or I want interim exclusive use of the home, or I want that car. A spouse can do that. And so you're putting together all of that paperwork for the interim, the motion for interim support. And it's not just like you're filing it in court. It's not that like, okay, I'm just going to file it, we'll get a hearing. It, you you have to call the court and get a date, and then go into the courthouse and get the judge to sign what's called a show cause order. And the show cause order uh, reserves the place on the court's docket for that motion. That's the whole purpose of the show cause. And so you have to put together a show cause order that has a motion and a declaration and an order, right? So those are all of the documents you need for like an interim um, uh, motion for interim support. Uh, there are going to be documents for if you are going to ask for discovery. There's something called a request for production. I don't know that you find that. Yeah, you will find that online. You can serve a copy of the statute. It's 107089, and you just serve that on the spouse, and they have to produce documents to you. But if they don't, then you are going to file a motion called request. What's it called? Order for discovery, motion for order for discovery, something along those lines. You're going to file that and get on the court's docket and go have a hearing. The judge will sign it. So this stuff just, and then the other thing to know is that every county is different. You kind of see me like just like kind of like going through things in my head. Like I'm trying to keep like track like what each county does. You can't, like you just can't. So every time like like I'm thinking about a case, it's like, oh, I'm in Washington County, they do it like this. Oh, yeah, in Washington County, you have to stop at the clerk before you go see the judge. In Multnomah County, they tell you um, when the judges are available, and you can just go speak to them. It's usually 1:30 every day. Clackamas, I would have to look it up. I don't even remember offhand. I've been doing this for a long time. So this stuff is, it gets confusing, and particularly if it's a contentious matter. So that's what you have to look forward to for a do-it-yourself contested case. And then there's no forms for this. At least I'm pretty sure that there's no forms for this. If you're getting into trial, you have to be able to put together a trial memorandum for the court that gives the court your outline of your case, so the court knows what to look for when the trial starts. You have to put together your exhibits. You have to put together what's called a assets and liability statement. It's UTCR 8.101 form, right? And it balances out the point of the assets and liabilities form is to show what an equal, even distribution of the parties' assets and liabilities would look like. So the list of forms for a contested do-it-yourself is long, and honestly, kind of, I'm thinking about it now, and I'm feeling overwhelmed. So there is a lot to know and a lot to do, and there are people who do it. There are definitely people who do it. They get to court and they make the best of it, and there are people who go to court and just flail. I've seen that too. So let's just get to the forms. All right. So here things might get a little complicated. I hope not, but let's just see where we're at. All right. You should see online services. Okay. So you can find this by searching Google for Oregon Judicial Department online divorce forms. And this is more than divorce forms, but that search term will get you here. So there are two different sets of forms that you can use for divorce. There's the interactive online forms, and then there's the PDFs that you can fill out and fill out the fillable PDFs that you can complete online, download, and then bring to the court. And then there's the forms that you can just fill out. They're not downloadable. I misspoke. They're not fillable. You just print out the forms and bring them into court. We're going to talk firstly about um, the Oregon Judicial Department guide and file forms. And you can find that here, Oregon Judicial Department online services. And read the instructions, read the instructions, read the instructions. This says what type of cases, divorce, separation of custody is what we're looking at. Come down here, start using guide and file now, and you are off and running. And so there's the system is pretty good. There's no question that this is a pretty good system that the state has put together. There's videos here that describe instructional videos here. And then here you can pick which set of forms you want. So the first question that you have to know is like what type of case is it? Is it a divorce? Is it a custody case? They're calling this unmarried parents. They're simplifying it, of course, or a separation. And are you the petitioner or are you the respondent? The petitioner is the one who actually files the initial pleadings. The respondent is the spouse who is responding to those pleadings. So it's a response filed by the respondent. And then you just go through it. Here's like the basics. This will help you file for divorce. Just run through these and just fill out the forms online. Here's quick tips. You can see I've already gone through this in anticipation of this evening, so it's already got some answers in it. There's some warnings about stalking matters, safety issues. This is asking if you want additional information about a divorce, a separation, or a custody case. Do you need help in another language? Okay, so here's where we're just kind of like going to start entering information, and you're just gonna go through and fill out these forms. You will need a fair amount of biographical information in addition to information about who's going to get what or about what the assets and liabilities are. So for biographical information, I think that there was a slide at the beginning that outlined what you need, but you'll need both spouses' names, former names, birthdays, driver's license numbers, social securities, places of birth, other names, employment information if there's children involved for child support purposes. And so you're going to need all of that information. You'll also need another category so that's biographical information for the parties. Another category of information that you're going to need is on the marriage. So obviously, date of marriage, place of marriage, county of marriage, date of separation. Those are all things that's going to be requested and you'll have to have access to. So I'm not gonna go through and fill these out. But you can see like we're all kind of used to this now from filling out online forms. When you get to the submit page, there'll be a page where you can review your answers, make sure that everything is accurate. And then you can do, the question then becomes, how do you get this to the court? And this system gives two options. One is that you can file the forms electronically online through the Oregon Judicial Department, through this process that you're looking at now online. Or you can print out the forms, the completed forms, sign them. You both have to sign them, and then bring them down to the courthouse and file them at the with the clerk at the courthouse. And the cost for filing for filing any divorce is $301. So you have to pay the filing fee and um, uh, just make sure that it's filed. If you file online, you will receive a confirmation from the court that the case has been filed. If there are parts of the documents which aren't correct, which is unlikely with this form, uh, you will get a notice back from the court saying, we've rejected your filing for the following reasons. And then you make the corrections and resubmit it. If they do that, then they don't, and you're doing it online, they don't charge your credit card. Like they just reject everything. Like they won't like accept a partial submission. So all of the forms that you submitted uh, are rejected. And that way the court doesn't have anything. There's no file set up. There's no case number assigned to your case. Um, so one advantage of using this system is that since you're using the state system, you're unlikely to have a form rejected and turned back to you. But if it does, you will get notice of that in an email. Um, uh, if you bring your forms down to the courthouse and file them there, the courthouses all have a family law resource center, and the people there will look through your forms and tell you if things are right. They won't give you legal advice, but they can at least tell you whether the forms comply with what's required by the courthouse. And so, right once you file them, you'll know right then and there that the forms have been accepted. If they hand them back, if they don't accept it, they'll hand them back to you and give you a check and say you got to correct this, and then you'll correct it. Uh, but I would think that filing it online is going to be convenient. If you have if you have an uncontested divorce, and this is important, I want to underline this. Underline, underline, underline. So I underlined it 3 times. Is that you are going to file everything together. You're going to file the petition, the confidential information forms, the vital statistics form, and you are going to file the declaration and the judgment. And both the declaration and the judgment need to be signed. The judgment, if it's stipulated by both parties, has to be signed by both parties. I didn't want to go through, when I was looking through this in preparation for tonight, I didn't want to go through to the end and file something just to find out how the signatures work on this. So there's got to be a mechanism for signing the documents through the OJD guide and file system. I don't know what that is, but if you're filing an uncontested divorce, that means that you're both going to sign the judgment, and you can't file it until both names are on the judgment, right? So this has to have a way to do that, but that's the way you're going to do the uncontested divorce. You're going to file all of those documents together at the same time. That's the way I've been doing it for years. That's not the way other attorneys do it. That's the way I do it. That way, it's the least amount of paperwork, and it's the most efficient. It's just the most efficient. Court gets everything at the same time, and then they sign the judgment, and you're done. It occurred to me that there's one other term that I didn't explain at the outset, but it's important now, and that's co-petitioners. Sometimes people call it and they want to do a co-petition divorce where there's not a petitioner and a respondent, but there's 2 co-petitioners. There is no procedural advantage or disadvantage to being a petitioner, and there's no procedural advantage or disadvantage to being the respondent. They both carry the same weight. It's just who got to the courtroom first. But for some people, they think that if like wife filed against husband, that wife's divorcing the husband and it doesn't look good or it doesn't feel good. I respect that, but legally it doesn't have any meaning. So sometimes people call up and say they want to do co-petition divorce. None of these forms are set up for co-petition divorce, but there are forms in the Oregon Judicial Department website where I'm sure if you have to look around for where you'll find a co-petitioners. You cannot do a co-petition if it's a contested divorce, right? The co-petitioners, it's anticipated that's going to be an uncontested divorce. So um, uh, that's just if it's important to you to have co-petitioners, you can find similar state forms here to do that. If you and your spouse aren't agreeing to everything, you can still use the Oregon Judicial Department forms to file the petition, the um, confidential information forms, and the vital statistics form. But you're also going to need to file. You're also going to need to get to find a summons because your spouse is going to be handed the summons and the petition, and then or maybe an acceptance of service if they just say, yeah, I'll just sign off and accept the service. And then you have to file the acceptance of service and the proof of service with the court. So you just get in the sense of like how much forms there are, right? And how many options there are and how many different ways to go. So if you're going like the contested route, you're going to have to find, and I know that the summons within this suite of divorce forms, you're going to have to print out the summons and remember to serve your spouse with the summons when they get handed the petition and the other documents. All right. That's everything about this online process. There's plenty. I've looked through the videos before, and they're pretty straightforward and pretty good. Not as good as mine, but whatever. So if you get caught up, you can check out the videos. I know that I've been told that people will call the company that puts this together. It's called Tyler Technologies. People have called customer service at Tyler Technologies, and have gotten some help with the forms doing it that way. Of course, they're not going to give you legal advice, but they'll help you navigate this part of the system. I was recently involved with a case where somebody thought that they had filed a form through this system, and it turns out that it wasn't filed, and it had some pretty bad consequences. So you want to make sure that you have some confirmation that if you're filing it online, you want to make sure that you eventually get back that email that says your documents have been accepted, or call the court and find out what's happened if after a couple of days you don't get that email. All right, so let's move on to the PDF forms. All right, so I am still in the scroll down a bit. I am still in the Oregon Judicial Department website, and I found this page by typing Oregon Judicial Department divorce forms. That's how I got here. You can see that like the bureaucracy calls this programs and committees, family law, forms, divorce, right? That's the way a bureaucracy thinks about where this is, as opposed to putting it up for the end user a little bit, making it a little bit more easy, but they don't. And just, well, I'm not going to get into an aside. So you have 5 choices here for where you're for doing do-it-yourself forms. Just a moment ago, you will recall I was talking about co-petitions. Here's the co-party petition. This is if you and your spouse want to do a co-petition. And I will show you what this looks like. So it looks, this is what the co-party petition, so you would download this, fill it out, and then bring it down to the courthouse with the $301 filing fee, and file it with the court. So I'm just looking at this now, and I'm looking at something really interesting. There's a mistake on this. The mistake is that it still here says petitioner. It's co-party petition. This should be co-petitioner, not petitioner and respondent. So whatever it's worth. But this is a co-party petition for entry of stipulated general judgment. This is a direct, you still have to fill out the other forms, but this is not like it's a little confusing. I know it's a little confusing. This is an abbreviated process with the co-petition, so that you're just filling out this petition, which is similar to the other petition, but this is specifically because it anticipates that you're going to be filing the judgment along with this, right? It even says here, co-party petition for entry of stipulated general judgment. So, like I said before, it's anticipated that if you're going to be co-petitioners, you're not going to have a litigated case. It's going to be a stipulated judgment. And here, you can have a stipulated judgment for custody, meaning that there's minor kids but no marriage, dissolution of marriage, or registered domestic partnership. And I don't talk about that because it just rarely comes up. Um, uh, of course, it used to be for same-sex couples. Now it's for non-same-sex couples. Um, and then registration is its own mess. And then status. Unmarried parents. This is not a good form. If it's just custody, it should be asking for these. This is redundant, right? So then it gets into residency, like we talked about. Like you have to be in Oregon for a certain amount of time, and then you have to have one of the venue, what county the divorce is filed in, is determined by where the parties live. It can be filed in either county where the either party lives. Here's for children, child support, then jumps down to retirement. Um, and then parties have reached agreement on all issues as specified in the general judgment. So what you put in the petition is it's kind of important. It's not really important. It's going to change later. What goes into the judgment is always what is the important thing, because it's the judgment that controls the post-marital relationship between spouses. All right, so let's jump back. We had a little detour there. Um, you're going to pick out which form is appropriate to you. If you are filing a petition, you are the petitioner with and without children. And then if you are the respondent, with or without children. So let's go with children. And this takes us back to the I-form online form that we're looking at a little bit. This takes us to a PDF package. And you will download this. And you will notice how much instructional. I'm just gonna scroll through this. You'll notice how much instructional material there are. The state is trying to like help people out by like giving people enough information that they don't need to hire a lawyer. So this is kind of just repeating what I've said. Dissolution case starts with the petitioner. Um, and then the general judgment will create rights and responsibilities that may be permanent, right? So it's the judgment that counts. So this is all just very basic instructions, but there's a lot of them, right? Um, you know, the state really worked hard to, create like forms and to give people information. But nobody's going to read through all this. It's naive to think so. Or if they do, whether they understand it, you know. So we're still going through like instructional matters. We're not even at the forms yet. We're not at the forms yet. We're not at the forms yet. Not at the forms yet. Not at the forms yet. Not yet. Now we are. So this is what you're going to fill out. You can download this and fill this out. And you start. All of these forms are going to require the same information. County of, you're not going to have a case number, so you can leave this blank. Fill in the petitioner, fill in the respondent. I don't need her, date of marriage, place of marriage, residency, like we talked about. One spouse lives in Oregon, and the spouse has been here for at least 6 months prior to the filing of the petition. One spouse currently lives in the county where the petition is being filed. All right. So you're gonna go through and you're gonna handwrite all of this out. Many people do. I mean, I see these all the time. People do it. It's not that hard. People can certainly do it. You're gonna bring this down to the court, file it along with the confidential information forms, which we'll get to. It's all one form. We're still on the petition. This is a the notice of healthcare coverage. This is the summons I was talking about that has to be handed to the other party. You're going to fill this out, fill this out, fill this out. Here's the vital statistics forms. It's included with this download. This is a fillable form. Yeah, this is a fillable form. So you can do this on the computer. Here's the confidential information form. You fill this out. This stays with the court. This is for one of the spouses. The other form is for the other spouse. This is the notice of filing, and that goes to the other party. If the other party will accept the petition and the other documents, then you can fill out this form, the acceptance of service. Straightforward form. If there's kids, you're going to fill this form out, which says that you've sent the petition to the Oregon Department of Justice, Oregon Department of Justice, to the Child Support Division, because they'll open a file in the event that there is a case for child support. We talked earlier about the declaration. Here's what the declaration looks like. I don't know. This says something that's strange to me. The statements made in the petition remain true and accurate, except, okay, so this is just saying that the petition, I don't actually think this is right. It's not that the petition is true and accurate. It's that the judgment is true and accurate. This is like I said earlier, this is like what I was saying earlier is that I didn't think people understood this. The statements made in the petition remain true and accurate. It doesn't matter what's in the petition. What matters is in the judgment. So this is it's an error. It's a misunderstanding of why the courts require the declaration. So anyways, doesn't matter. I'm just kind of on a rant. So you'll fill this out and submit this along with the judgment. If it's an uncontested divorce and both spouses are signing off on the judgment, right? And so that's what I said earlier. I hereby declare that both statements are true and complete to the best of my knowledge and belief. I understand they are made for use as evidence in court, and I am subject to the penalty of perjury. And here's the judgment. So, excuse me. The judgment is the document that controls post-marital relations. This is what needs to be accurate. This is what needs to reflect your agreement going forward, how the property is divided, how the debt's going to be divided, whether the spouse or the kids, all that goes into the general judgment. Like I'm just going to say it again, the three ways that you can get this signed by the court is by both parties agreeing to it, which is generally what an uncontested divorce, not generally, which is what an uncontested divorce means in this context. You go to court and there's a trial and the judge signs this and then you don't, or there's a default judgment. And like I said, we're not going to get default judgments. This is the form that you're going to fill out. You're going to take your time. You're going to be accurate with this. I know I'm just scrolling and you can't read. I mean, I know that, but I just kind of want to get through just to show you how much there is here. Um, the judgment is divided into three different parts. There's the findings, there's the recitals at the beginning, and there's the finding of facts, and then there's the order. And within the order are the judge's orders, and then there's the judgment. It's actually the judgment, and that is called a money award. This is the part that gives you right to collect, to like garnish wages and things like that. That's what this money award does, right? So it's breaking it down by us, child support. Uh, there's a spousal support, uh, money award. There's a property division. Uh, uh, um, Normally, this property division would be called an equalizing judgment, which is what I was looking for just now. But they're simplifying and calling it a property division. This could be like a lump sum or paid over time. Um, and then the judge's signature, you have to sign down here and swear that uh, this is ready for the court's signature. So that's what this is for. And then here, what I've been talking about, a stipulated judgment is where both parties sign. Signature, signature, and if there's a child 18, 19, or 20 uh, who is in school, that child signs here too. And then this gets into default judgments, and we're not going to go into that. I want to show two more um, quick forms that are important, and I just we're at the end of the hour, so I'm just going to quickly. We are right at the end of the hour. I'm just going to quickly show you where those are. Oregon Judicial Department, um, parent parenting plan. Here, if there's kids, you're going to want to attach these basic parenting plans to the judgment, right? And like I said, I like these forms. These forms in particular are well laid out, and they cover all of the possible variations in a parenting plan. So you will need, and these are fillable. So you can you fill this out, download it, attach it to the judgment. I'm not quite sure how that works, honestly, with the online forms. Uh, but if you're going to do it by pen, uh, download it for kids. This is what you do. And then the last form I mentioned was um, the child support calculator, and that's at the Oregon Department of Justice website. It's child support. You fill out all of this information. And I have other videos on this. If you're interested in child support, there are a couple of other uh, webinars on my website that go do a deep dive into child support. But the net result of filling this in is a child support calculation. And that calculation, it's just pages of forms and numbers, that gets attached to the judgment as well, uh, if there are kids. So I'm going to come back in just a second, and I am back. Um, Thank you for watching tonight. I'm glad we had a good crowd, a good turnout tonight. So I'm glad that um, people tuned in. I hope this was helpful to you. Again, my name is Stephen Leskin, and I'm an attorney in Portland. And please feel free to give me a call. Thank you.